A decision as a backbencher to vote against one's party ought not to be taken lightly. Political parties depend for existence and success, not so much on the holding of identical views, as on a shared philosophy and ties of loyalty and respect between members. So there are good reasons to try to find compromises when differences emerge on a specific matter. Last week, however, I voted against my party on a national issue for the first time in my 20 years in Parliament. I felt I had no option, as the attempts I had made to get the matter resolved by compromise had failed. I also considered that the matter was far too important to be ignored. It is troubling that much of the controversy brought in allegations of an intention to sabotage Brexit. The vote was not about stopping Brexit. As a matter of international law, Brexit will occur on March 29, 2019, and a refusal by Parliament to approve a final deal cannot prevent this, as it could only happen by the agreement of the UK and each of the other 27 member states, either to rescind the Article 50 notice or to vary the date of departure that Article 50 prescribes. The EU Withdrawal Bill, once known as the Great Repeal Bill, is going through the House of Commons to repeal the 1972 European Communities Act and transpose all existing EU legislation into domestic UK law, which will avoid a cliff-edge change on the day after we leave the EU. Parts of the bill have been highly controversial, and MPs have tabled hundreds of amendments to try and change its wording, including a significant number of conservative rebels. Some of the key controversies include its use of so-called Henry VIII powers, which will give government ministers the power to tweak the wording of laws to make sure they make sense in UK legislation, but those changes could take place without having to go through Parliament. MPs have called this a power grab by the government. The government estimates around 800 to 1,000 measures called statutory instruments will be required to make sure the bill is applied correctly. Other concerns include the government's decision not to include the EU Charter of Fundamental Rights in the law being transposed. Other amendments are attempts to affect the Brexit process, including legislating for a transitional period and giving MPs a binding meaningful vote on the deal secured by Theresa May, before the deal is finalised. The problem on which I focused is that, in order to take us out of the EU, the government is seeking, in Clause 9 of the Withdrawal Bill, very extensive powers to implement whatever changes the withdrawal agreement it is trying to negotiate may require. Yet until we know what that agreement is, the need for these powers to rewrite laws by statutory instrument is hypothetical. The government has accepted that a completely separate piece of primary legislation will have to be enacted to approve any withdrawal agreement. But the powers being sought could be used to bypass the promised parliamentary scrutiny of the final agreement, or avoid its outcome. I and a number of Conservative colleagues considered this unacceptable.